Good morning and welcome to everyone to our CEO series hosted by the CEO Training Division. My name is Carl Ranger, Head of Training, and today's topic we'll be discussing to be an effective and incredible witness. Today I'm joined by Shakti and Tammy, two of my colleagues who are Senior Dispute Resolution Officials. Welcome, guys.
Thank you very much, Carl.
Good morning to our viewers and thank you for having us.
No, it's a pleasure. How are you guys doing this morning?
We're great. And yourself?
No, I'm well, thank you. Thank you so much for joining us. All right, without further ado, let's get the show on the road. Just as an introduction, I think we've already touched on this, but just for our viewers, our contact details are on the slide over here. So if you have any questions or queries or maybe some comments, you can also email us directly, maybe on something one of us have said that you'd like further information on. To our members, please feel free to pop us an email or give us a call as well. And again, welcome everyone. We're excited to be hosting this monthly training. It is a continuation of our training series, which I'll touch on in a little bit. But because we are on a time limit and constraint, we want to just get straight to the housekeeping and then hand over to our two presenters today. So as you guys have known, if you've watched our previous training, we are streaming on multiple platforms. So it's YouTube, LinkedIn, Facebook. And you can tune in on your PC or on your smartphone just via the link. It is complimentary training, so it's free. And obviously it is online here. The video recordings and slides, we get queries on this every single time. So I just want to reiterate again, the video recording together with the slides will be uploaded if you missed the live training. It will be on our social media. It'll be on our website as well, uploaded there. So you can access the recording and the slides thereafter. Just a quick shout out to all our viewers from our previous training sessions. We reached quite a large number of views. So thank you so much for liking and sharing and participating. We really do appreciate all the interaction. On that note, please don't be shy to participate. We can't see our viewers, but we can see the comments that come through. So please feel free to add your questions to the comment section. You can look at our banners that'll go across the screen as well if you're interested in joining as a member or you want to be redirected to our website for further information. So please feel free to comment. It is a discussion that we want to have with you guys today. I think it's an important discussion to have, and also we are making it a little less legalistic in order to obviously equip our members and prospective members to be effective and incredible witnesses on the stand at the CCMA during arbitrations or even in the Bargaining Council. Without further ado, I hope you guys enjoy it. So just as a purpose of today's training, we, as always, wish to empower and equip our members and prospective members. The CEO Training Division is a platform of support, and we wish not just to inform you, but to transform your perspective on how we see things. And hopefully you guys get a little insight from or peek behind the curtain of how we do things on our side. We hope that you guys leave you informed and knowledgeable on the topic. We wish to obviously foster growth and development, not just within your business, but also amongst our relationship with us and our prospective members, as well as our members. Today's topic specifically, we hope that you understand what it means to be an effective and credible witness. We'll be dealing in detail with credibility specifically. As a follow-on from our previous training, which dealt with evidence, we touched on witness testimony there as a part of evidence that is led. And obviously, we'll be dealing today with the elements of witness testimony. We will do a brief recap on the admissibility and hearsay evidence specifically to understand credibility in the context. And then Shakti will be leaving us with some useful tips for people who are maybe first-time witnesses. It can be a bit daunting. For us, obviously, that's something we deal with every day. So I think it loses that spark of nervousness going to an arbitration and being on record. But we'll walk you through it, that you are better prepared and feel comfortable going in as a witness. All right. On the agenda today, as I said, this is a part of our series piecing together the processes and the puzzles of this whole arbitration process. We've done from the processes and disputes to the evidence that's led. We've dealt with arbitrations, evidence. We're now dealing with witness testimony specifically. We do have follow-up training, which I'll address at the end. As I said, if you have any comments or questions, please feel free to pop them there that we can deal with them as we go. On the agenda today, we'll be dealing with what it means to be an effective and credible witness. We'll be touching on the elements of witness testimony. Tammy will be taking us through a recap on admissibility and hearsay evidence from our previous training, whereafter we'll hand over to Shakti for credibility of witness testimony and then tips on being an effective witness. All right. Tammy, you have the spotlight. Thank you so much for being here. I look forward to hearing your discussion, and you can take it away.
Thank you so much, Carl. So with today's presentation into perspective, I'm going to be taking a more practical approach and use a lot of examples that I have gained from experience at the CCMA during arbitration processes. And when we look at today's topic of what is an effective and a credible witness, I think the starting point is very important to say the term witness. Now, a lot of the times in experience, we've had people come to the CCMA testifying, for example, in terms of a strike that has become chaotic. There has been violence, etc. And when it comes down to cross-examination of the witness, we later hear, oh no, I was actually at home, but this is what I heard. So from a starting point, what it is to be an effective or incredible or a credible witness, you need to have been a witness themselves. So starting from that point, having your witness who was actually there, who saw or heard or took part in a process, that's what you need to start off with. Then we go into what makes a witness credible. And to gain a better understanding of what a credible witness is, I did a bit of research in terms of Stellenbosch Farms Winery Group versus Martel and others. In this case, the Supreme Court of Appeal developed some sort of a test or some sort of factors that the courts and arbitrators particularly need to consider as to what makes a witness credible. Now, the term credibility of a witness particularly ultimately means the believability. You can have multiple witnesses at an arbitration process coming in, saying all sorts, testifying to a version, but at the end of the day, they don't hold any weight if they're not believable. So ultimately, the credibility or effectiveness of a witness is their believability. So with going back to the Stellenbosch farm case, the courts developed a few factors that arbitrators consider and what they need to look at to determine whether a witness is actually credible or not. So I'm going to go through a few of those examples with you now. So the first one in terms of determining credibility of a witness is demeanor. A lot of people in their fields of expertise go to work and have never been called to be a witness before. They are nervous, they're unexperienced, but ultimately when they come to the CCMA or Bargaining Council, their demeanor plays an important factor. Commissioners are also human, so they are aware that these people, witnesses coming in to testify, are a little bit nervous. They don't know what to expect, but the demeanor and character of a person coming in also shows a lot. It's almost the foundation or the starting point of their credibility. If they are hostile, resistant, those are all factors that a commissioner looks at from the onset. Another factor that was pointed out by the courts was bias. Now, this can go into multiple issues, like Cole actually mentioned on our previous presentation. You know, in terms of bias, he alleges it must prove it, but in terms of an effective witness, you want somebody who doesn't come in with a biased mindset or prejudicial mindset or stereotypical mindset. Those are also factors that determine the credibility. Another point that the courts looked into was contradictions. When a witness is testifying, how are they testifying? Are they saying the same consistent version during the examination in chief, during their cross-examination, during their re-examination, or are there contradictions in their versions, or is their version changing at each point? So these are also things that the courts take very seriously in terms of determining the credibility of a witness. Another factor that the courts are looking at, and at the CCMA, arbitrators particularly, is the probability. So you can have a witness coming in and telling their version of events, but whether they get to what the outcome was, the commissioner will sit back and determine, well, was this actually probable? Was the sequence of events there, or had they started somewhere and ended somewhere else? Another factor that the courts looked into was the performance of the witness themselves. So in a majority of cases, you'll have two opposing sides giving two completely contradictory versions. The commissioners are appointed to look at the performance of each witness and to determine the credibility therein. And lastly, and most importantly, is independence of the version. And this has been touched on, and I will touch on it again throughout my presentation. Independence of your version ultimately means not being coached. So what you want is a person to come in and just to display their version from start to finish, how they experienced it, and so on. With that being said, what does this mean to be an effective witness, and how does it affect the context of the CCMA and Bargaining Council? Well, ultimately, any case, whether it be for dismissal for misconduct, incapacity, any factor, you need a credible witness to testify. I'll give you an example. I've had this in multiple cases myself in personal experience. In the example of a security company, we have an employee who was caught sleeping on duty, which in most cases is a dismissible offence for a first offence. The company feels very sufficient. They've got the CCTV footage of the employee sleeping. But now it's all good and well. We've got the evidence of the person sleeping, but that has not been presented. And at the CCMA and Bargaining Council, what we need then is a credible witness to come in and to lead that evidence. That evidence will hold little to no weight without the witness testifying to it. On the day in question, I arrived, I walked into the room, I saw the person sleeping. Therefore, I put my phone on and recorded it. While I was recording this employee sleeping, you could see he was cozy, he'd made himself a bed. I called out to him, he did not respond. So these are examples where you can have the evidence of the video footage itself, but without the effective witness to testify and to become credible in their believability of what actually transpired, the evidence itself will hold little to no weight.
Sorry, Tammy, just to jump in there. Sorry, I'm burning to jump in because I think it's something that we had discussed previously. And we've touched on this in the previous training, specifically when it comes to evidence. Your evidence is only as good, and this is from a representative's point of view, is only as good as your witness who introduces it. So you might have prima facie evidence for a certain offense that shows, listen, without a doubt, this person is guilty. However, that evidence still has to be introduced through witness testimony by the relevant person, whether it's video footage, the person who had control over the video footage, who took the video footage, who was like our witness, for example. If they have a shoddy testimony or they don't seem credible or believable, it doesn't matter how strong your evidence is, the witness testimony that goes with it doesn't match, for example. So it's so important that your witness comes across as an honest, credible person. And I think that plays into the significance of what you're trying to say here as well.
Absolutely, Carl, 100% agree. And that's to the next point, the role of witnesses in proceedings. Ultimately, with any case, whether it even be a 73A money dispute, you have to have a witness and who is a reliable, credible witness to come and testify exactly what transpired in order to present the evidence, the calculations, or like this example, the security officer to present the evidence. So in essence, the lack of witnesses in a case can ultimately make or break a case. The significance of credible witness testimony, what it comes down to in terms of the balance of probability. So ultimately, the arbitrator's primary function is to determine whose version is more probable. And we've discussed it again, the Lady Justice, the scales, who's more believable. And in order to be believable, you have to be credible. And that will go back to my first point where I touched on the factors that the court presented. There's multiple factors that an arbitrator will consider to determine, okay, based on all these characteristics, this person is believable, and based on their believability, they therefore become much more credible.
100%. Sorry, no, I just wanted to say, Tammy, I think, these are the elements that us as representatives are going into an arbitration for. We're thinking about the legal technicalities, what the commission is considering behind the curtain. Whereas, for the witness themselves, maybe the person doesn't have much legal experience, or maybe it's their first time testifying. As a natural person on the stand, you would be thinking, I don't know any of the stuff that you're trying to consider. So what our advice to a witness would be is just tell the truth, tell it the way you remember it, and make sure that your version is consistent in that sense. But what it comes down to, and it's something that I've always advised our members, is the commission at the end of the day is going to ask a simple question: whose version makes more sense? Is it the applicants or the employees, or is it the employers? Which one makes more sense on a balance of probabilities?
Absolutely, Carl, I agree with you. And when I go further into my slides, I'll also break that down, because it seems as simple as that, just come in and tell the truth. But that's where, for me, very important is preparation. And that is something that I'm going to discuss quite at length. But absolutely, that is what the presiding officers make their decisions based on. And that's exactly where witnesses fall in. Perfect. If we can move to the next slide, please, Carl. Thank you. So the simple question of whose version makes more sense, the basics. So this is where I can almost do a full 2-3 hour presentation on preparing for testimony. This to me is the most important thing. For us as legal practitioners, and the way we practice, is preparation for arbitrations is key. So for me, I'm going to give you a practical example. I had an arbitration scheduled for a discrimination matter based on sexual harassment. So in this case, before my case was scheduled to proceed, I went to the employer's premises and I needed to inquire, first of all, did this allegation actually happen? Who was the witnesses to it? And in this case, there were actually multiple witnesses. And this is where, for me, preparation is essential for any witness. What I did in this example is I had one-on-one, without the employer, without any HR, without any other parties involved, had one-on-one preparation sessions with the witnesses to find out what did they actually see, what did they hear, and based on that, to be able to compare the evidence and to see if there was any inconsistencies. The last thing you want is to call a witness to the CCMA or Bargaining Council to arbitrate, and that person is going to say something that is completely untoward or is completely damaging to your case. So it's not coaching, but it's to go and to find out exactly what that person knows, understands what their version is going to be on the day, and to see if there's any consistencies. I think at that point also, for somebody who's seasoned, would then also in some sense challenge the version that the witness is putting before the arbitration date. So if there are any cracks or loopholes in the case, you can then narrow it down and ensure that that witness maybe is not used, maybe not called because they're not beneficial to your case, or rather used. The next point in terms of the basics is the oath and affirmation. Again, going back to the preparing of your witnesses, for me, when you go to the CCMA or the Bargaining Council, a witness walks into a room, gets told to sit down, and the commissioner straight away says, okay, before you present your evidence, you need to take the oath or affirmation. For somebody who's never been at the CCMA or Bargaining Council, this can be a very daunting experience. This can completely shake your witness unnecessarily. So again, I go back to the preparation, while prepping leading up to arbitration, to explain to your witnesses, to let them know you will be required to take the oath or affirmation, to lift your right hand, say, do you swear to tell the truth and nothing but the truth so help me God? Or yes, I confirm to tell the truth. And this is something that is quite important, that if the person or your witness knows that when they come there, this is what they're required to do, this little technical administrative part does not then become a daunting process, does not throw them off, in terms of their confidence. And I think it's something, again, very important with the preparation and how important it is to prepare your witnesses so that they know everything that is expected. And this is something that I know is forgotten a lot.
Tammy, sorry, just on that point, I just wanted to say I've had a scenario in the past where one of my witnesses were busy taking an oath. They lifted their hand and they were asked by the commissioner if they feel comfortable taking the oath. And my witness said, no, I don't. So, you don't want to coach them or anything, but you want to, just inform them, as you said, that, you'll be taking an oath and this is how it goes. So they feel comfortable, because they answered the complete wrong thing and said no instead of yes. And I mean, that's a big problem going into witness testimony. So yeah, just as a little funny thing that happened there.
Absolutely. And again, when we go back to looking at the factors that we considered in terms of what a commissioner looks at, the demeanor, all sorts of factors, if you say, no, I don't confirm to take the oath, that already is not putting you under the tick box of a credible witness from the onset. So again, I think preparation could easily eliminate that sort of confusion like you experienced, Cole. Then if we move on to the next point, the duty to tell the truth and the legal and ethical obligations. I mean, in our experience, or in my personal experience, I really feel that when I've prepped with my witnesses, we can also tell from our experience whether people are lying or whether they're being coached to say something certain when you test the version. But there is a I think in most people, there is definitely an ethical obligation in the back of their minds to tell the truth. With that being said, I think nobody can ever be 100% confident that the person will not lie. And I think that's also, again, goes back to preparation in terms of prepping your witnesses, checking their versions to be able to tell whether you believe that this person is being truthful or not. And then importantly for me, the legal obligation. Now, this could be a bit of a gray area in terms of what should be done in preparation sessions or not. It has come out on multiple occasions in my experience where we have witnesses who put down a statement, make a version, and then at the CCMA later change their version. I think it is also important in terms of your preparation session with your witness to explain, this is a statement you made 2 months ago about the incident in question. This is, let them reflect upon it. Do you recall writing it in your own handwriting? You signed it and dated it. Now, if we go to the CCMA, are you going to say the same thing? If they confirm yes, they are, then you're happy and proceed. But there is a consequence if they don't. I mean, ultimately, if you are now going to change your version and in essence lie, become dishonest, there is also possible legal ramifications for that, and that you can be held liable in terms of dishonesty and can ultimately be charged and dismissed for such misconduct. So in terms of prepping your witness and having credible witnesses, ultimately, I don't think employers should be going around using that as a sword to kind of threaten to say, if you do not, you will be dismissed, like you need to go with my version. But it is to also remind witnesses themselves that there is an obligation on them, if that is their version and they said that that is their version, to ultimately stick to their version and to not deviate, because there is ultimately consequences. I do remember in the past also I did a case for quite a big organization of the dismissal of the HR manager of this organization. And when it came out, the arbitration was successful in the employer's favor. But when it came to the applicant's version, the commissioner's opening statements, obviously they have the applicant's name and they're under his version that was testified to in the arbitration. And the commissioner's opening lines was, the less that is said about this witness's version, the better, because his version was so unreliable and actually shocking. Now, ultimately, we need to remind witnesses that an arbitration award is a public document. Their name is there and what they testify to. And ultimately, a commissioner puts their input on what you've said. So you don't want to have a scenario where there is a public document floating around with your name on it, where you have completely contradicted yourself, because in the long run, job seeking or just, morally for your own, the sound of your own mind, you don't want a document saying that you are untruthful, you're unreliable, you're unhonest. So that's where you need to ensure that you are prepared, that you know what you're going to be talking about, and that you're ethically and your obligations are correct. If you say you said something, to stick by it.
Yeah, and also the consequence of lying under oath is that you're perjuring yourself. So you can also be held, in contempt, for example. But there's our advice would be to just tell the truth. Even a lot of people's truth is relative to their version or how they remember the facts. And maybe if you get really semantic with it, truths can differ from one person's perspective to another. But at the end of the day, it is important that witnesses do tell the truth as they remember it on the stand.
Absolutely. If we can move on to the next slide, please, Cole. So in terms of the elements of witness testimony and what they are, we have quite a big block here. And again, we will go back to preparation. This is something that I cannot stress enough. For me, as the founding block, like we've said, in essence, you cannot have any real case. You can have all the evidence, but without having a credible witness, you actually have no evidence to present, despite the evidence that you have. So for me, advice in terms of preparation for a case is the most important. To get your witness statements, or to go back and reflect if you have witness statements, to check the versions of your witnesses, to see who was actually a witness. Again, back to my first point, ensure that the people that you're calling were actually witnesses. Go through the preparation in terms of what did they actually see, what did they experience on the day. Ensure that they know what's expected. So at the CCMA or the Bargaining Council, let them know that this is what is expected of them. This is the process, like we touched on in the previous two slides, was the oath. Let them understand and know what it is that is expected. And I think a prepared witness is always able to present themselves as more credible because they know what's expected of them. If we move then on to truthfulness, again, we touched on this element in our previous slide with regards to, the obligations, but also the consequences of not being truthfulness. And ultimately, again, the credibility of a witness relies on their believability. If you are truthful, you can be asked and cross-examined on the same facts 100 times, but your version will be steadfast and will be consistent. So truthfulness for me is the most important. And that's where we always promote ensuring that you have the accurate witnesses of the day, not to try and make up a witness to try come in and fill up a blank, or if you feel like you don't have enough witnesses, rather leave it consistent with one honest, truthful witness who was there, who can testify to exactly what was seen, than rather to try and pull in one or two other witnesses who may or may not have seen exactly what you need them to have seen to present your case. So truthfulness is very important, and ultimately it goes down to the believability of the commissioner. Commissioners are human, but they're also very experienced. They on a daily basis listen to versions day in and day out. And I've seen from my own personal experience, some commissioners within a few minutes are able to determine whether a witness is truthful or not. So it doesn't matter how great your acting skills are, but to rather always ensure you have the correct witnesses there. And ultimately, if they're truthful, their evidence will come across as a lot more credible. The next point is personal knowledge and experience. So although this will touch onto the element of an expert witness, I can again give a very good example of a case that I did for an incapacity, dismissal related to incapacity. So this employee was quite a high earner, earning 55,000 Rand a month, was appointed as an IT developer. And the employee argued that, he did not have the experience and the knowledge, etc., to be able to perform the job and should not have been dismissed. In this case, I called the manager that directly consulted with the applicant during the incapacity process, as well as the manager who appointed him. And if there was one thing that I learned from this case, is the term Python. It's IT development of some sort. But that's where it becomes very important. For example, in this scenario, it's important to explain to your witnesses in your preparation that in this IT example, they are experts in the field. They know what is expected of employees in this field. They know what is right, what is wrong. Us as legal practitioners, we are not experienced in IT, for example, or in the medical field, but the witnesses themselves are actually specialists in their field. They know on a daily basis, they work at the same company, they know what the standard procedures are, they know what's expected of a person with certain qualifications, with certain job requirements. So the personal knowledge and experience also goes a long way. And that's also, again, going back to the preparation, to let your witness know, remember, you are experienced in this field. You need to help me to understand it, to be able to then help lead the case going forward. But ultimately, if you have your knowledge and experience, it will definitely assist in terms of your credibility of explaining to the commission, narrowing it down, and just explain what is expected in your particular personal knowledge and your experience in your particular field. Then if we move on to relevance, this also, again, can become tricky and always goes back to the preparation. So we've had it many times where you'll have a witness come in and they start testifying about things that happened in the past. So, for example, if your witness is testifying about absenteeism and an employee has been continuously absent, but then all of a sudden in cross-examination, they get asked about a warning for negligence, and then the entire version twists, and now they are off and talking about negligence in this one time back then when the truck hit the wall, and you've completely deviated from what is expected of you. Again, this goes back to the preparation, and what I find very important when preparing with your witness, to let them know that be careful not to be deterred or to be taken on a completely different angle, where you are then talking about irrelevant factors. And I also don't, obviously for me, this is where our job as the representatives come in to then object at that point and raise the point of relevance and try and steer the point back. But also, especially with the more experienced witnesses, they themselves raise a point. If they get asked questions that are not relevant to the facts of the case, I say to them, don't feel intimidated or shy to say, I don't see how that is relevant. You can give a short answer, but please don't be stirred into answering a whole bunch of information about something that is not the issue in dispute of the case.
I think from a commissioner's perspective, it also shows the experience of the witness. A witness who testifies regularly at proceedings, maybe an HR manager or an initiator who handles a disciplinary action from a business side. When they come testify, they get to the point of what they wanted to say because it's relevant to the dispute at hand. Whereas your less experienced witnesses, and I see this with applicants as well, employees who've maybe been dismissed, they will ramble on and on and on about something that is completely irrelevant. So you'll raise that objection, and it is quite a common objection to be raised from both sides as well.
Absolutely. And ultimately, I mean, for me, sometimes, depending on the commissioner, some commissioners will allow it to go to a point and others not. But ultimately, again, you don't want the commissioner to lose track and to focus his attention then on something else that he might want to consider later on. You always want to focus it back and bring it back to what is the issue in dispute, or what is the issue at hand here that we need to present our evidence on. With that being said, we move on to the next point, which is confidence and clarity. Now, this is something also that, again, to me, goes to the preparation. If a witness knows what is expected of them on the day, for example, what does the CCMA or Bargaining Council look like? It is not a court where there's a judge sitting up at the top that they're going to be pushed into the corner of a witness box and be all isolated and alone. If they know they're going into somewhat of a boardroom, they know roughly where they're going to sit. If they know what's expected of them from that point, they can immediately come in a lot more confident and not nervous. Again, confidence. I believe commissioners are very mindful of the fact that, unlike in Cole's example, the HR manager, for example, will have a lot more experience in these proceedings. There are witnesses who certainly come in, this is their first time testifying, they are nervous. Commissioners are mindful to this fact that they do know that witnesses come in are not going to automatically be confident and speak clearly. But in terms of your preparation, again, I go back to if you've prepared your witness of all the possibilities of what to expect, how the process runs, what is expected of them, they will automatically come in a lot more confident because they know what's expected. And again, in terms of the preparation, to explain to your witness that they need to speak clearly, that they need to speak quite loudly in order for the commissioner to ensure that he hears the crucial evidence. You don't want to record something to say it is, and the commissioner has recorded it as is not, if they did not hear the words correctly. You need to be clear and audible, and also to speak at a pace where a commissioner can record. A lot of witnesses also don't know that commissioners need to either orderly or manually write down the version. And some people are so nervous that they will just rattle on. And if the commissioner says, please slow down or stop for a minute, I need to record, then they get completely taken aback and lose their confidence in what they're saying. So again, I think it all goes back to the preparation of your witness. If they know what's expected of them, they know the truthfulness of their version that they're going to present, you can stop them at any stage because they know exactly what they're going to say. They know exactly what comes next. Move on to then prejudice and bias. Again, this is a challenging one because ultimately you want your witness to go in with an open mind, to not present any type of prejudice. It has happened in the past again, where again your preparation with your witness to let them know exactly what to expect. And then in terms of bias, there is always this misconceived notion that if you've brought a witness if the employer has brought a witness from the workplace, that person is automatically biased because obviously they will then say what their employer wants them to say. And I mean, we know from practical experience that we think we'll have the best witness, and that witness can turn around and say the complete opposite. So again, it goes back to the allegation. If somebody wants to allege that there's been bias, they then need to prove it, because I don't believe, especially, I don't know from my colleagues' experience, but in today's day, the allegation of bias or automatically telling what the employer wants you to tell, I don't see it practically happening on a case-by-case basis in my head.
There is a perception of, obviously, when a witness is on the stand, that they are being truthful. That is the inherent perception after taking the oath. Biasness, as you say, will have to be alleged first and then proved by the party alleging. Just because you're testifying on behalf of the employer or in the employee's perspective on behalf of the employee doesn't inherently make you biased.
Absolutely. If we move on to the next point, which is credibility, again, credibility is what the crux of our whole presentation is really, and credibility is the believability. And like we discussed in the previous slide, the credibility is not one element. Credibility is actually made up of a whole bunch of elements, including your confidence, your demeanor. So ultimately, at the end of the day, if you are prepared, if you know what to expect, you automatically become confident in what you're saying. If what you're saying is truthful, ultimately, I believe you can only be a credible witness based on that. It doesn't matter what the cross-examination is. If things get hostile, you can still retain it as long as it comes out that the commissioner says, after the evidence has been led, this person is believable, and based on what they've said, I believe what this person is saying. Then if we move on to the next one, actively listening and responding. This, again, goes back to the preparation, and an element that I think witnesses need to be prepped on quite significantly. In my experience, my colleagues on the other side of the table, particularly our trade unions, have got a very, very clever technique when it comes to questioning. And this is something that I always prep my witnesses of in advance. A typical example would be a statement will be made, which the witness will automatically agree to because it is correct. But at the end of that statement, they will throw in a question which the opponent wants you to agree to, which is incorrect and contradictory to your version. And this is where active listening becomes crucial. You want to, what I always recommend to my witnesses, not to seem hesitant or hostile in answering questions, but if a question is posed to you, stop, take a second, take a breath, understand the question, and then answer. In the event that you are given either a statement or a question in one, either stop and ask them to split it and answer one and then the other, or alternatively, make it clear on the record, to answer your comment, I am answering X, Y, and Z, and then to answer your question, I am answering X, Y, Z. It is very important to place it on the record because a simple yes or no answer could completely change the version. And that's why active listening and responding for me is also, again, going back to the preparation, that witnesses need to know what is expected of them in terms of answering, but also not to be too hasty to get the process over and done with quickly, but rather to listen carefully and know what's expected, because the answer to one or two simple questions can completely change their version or completely destroy their credibility if they would have then been a contradictory witness.
Yeah, I think, sorry, I just want to say one quick thing on that. I think a lot of people, just in life in general, listen with the intent to respond, whereas my advice would always be listen with the intent to understand. Once you understand what you're listening to, then you can respond effectively in that regard.
That's a very good point. I'm going to write that one down. Thanks very much, Cole. That was very good. If we move on to the next point, respectful conduct. Again, this is just for me from a practical experience, just to, again, in preparation sessions, to let your witnesses know what is expected of them. I have had it in my experience, where a witness, for example, will walk in with a bowler cap on, chewing bubble gum with headphones in their ears, lying back on the chair, waiting to be addressed. Now, again, although it shouldn't, in essence, go to what they're about to say or the evidence they're about to lay, but like we discussed in the Stellenbosch Farms case, the commissioners look at the demeanor of the witness. If you've come in completely disrespectful, immediately you have got the backup of a commissioner who is already put a spotlight on you. It doesn't matter what you're going to say thereafter. It is very important to come across in a respectful manner. For example, in my preparation, I always say to my witnesses, please make sure that your phone is on silent. Please come in, sit up straight, and don't be digging in your bag to try to find a scrap piece of paper. Those are things. Respectful conduct is something that needs to be considered. Expert testimony. Again, this has been discussed by my colleagues Arlene and Stephen in the previous presentation. Ultimately, an expert testimony is there to assist a commissioner to get to the conclusion of the matter. But that has been touched on, so I won't go too much into that. Non-verbal communication. Again, if a witness is testifying, if you're a witness, your behavior such as slamming your hands on the desk, pulling a face when the question gets asked to you, huffing and puffing, these are all things that a commissioner takes into consideration. Then lastly,
sorry, Tammy. No, sorry. I know we are obviously on time constraint, but I just want to say body language is extremely important. Non-verbal cues, it's easily picked up on how you presenting your evidence.
Absolutely, and we've seen it in the past. It doesn't go well, doesn't go down well. So rather just reserve yourself. And I think also goes back to the preparation of your witness to let them know they will get frustrated or flustered, but to just remain calm. And then lastly, the rules of testimony. Again, for me, going back to the importance of today's matter is the credibility of the witness, for your witness to know the rules of who, what, when, where, and how. So during your evidence, to know the chronology of events, the sequence of events, and to just speak to the basics in terms of the rules of testimony ultimately will lead to a more credible witness.
And that's something that we'll touch on in our next training when it comes to trial advocacy, where we'll deal with examination in chief, cross-examination, re-examination, and the order of it as well.
Absolutely. Thanks very much, Cole. We can move on to the next slide. So just briefly, and again, I'm going to encourage everybody watching to go back and to have a look into the video that Stephen and Arlene Jacobs did with regards to admissibility and hearsay evidence, because they went into it in quite significant detail and gave great examples. But just to recap again, admissibility in terms of evidence is what is allowed and what is not allowed. So in terms of purposes for this example with a credible witness, for example, the witness makes her written statement about the sequence of events, that evidence generally will be admissible. If we have evidence of an employee who has maybe bugged an office and not being a party to that conversation and now wants to bring that recording, that may be questionable in terms of illegally obtained and ultimately will not be admissible. But in terms of admissibility of evidence, that's the commissioner's role to determine whether they will be admitting that evidence or not. And there is no steadfast rule, but commissioners then apply their minds based on case law, based on the scenario at hand, whether they will allow certain evidence or whether they will not. Hearsay evidence, again, for the purposes of credibility of a witness, and today's case, hearsay evidence in the most easiest form is broken telephone. So-and-so told me so-and-so, and now I'm going to tell you. So in terms of being a credible witness, hearsay evidence can be allowed in certain circumstances, and with the exception, for example, if I'm going to come as a witness and testify that Johnny told me he saw the employee take the oil drum, and then, there's an objection to hearsay evidence, but I can then confirm, but after myself, Johnny will come and testify. So he coming to testify will then prove my version and help me to be a credible witness. And those are scenarios when, for example, hearsay evidence will be allowed. Again, the relevance in ensuring that testimony relates to the issue at hand. My advice for members or anybody watching is always to ensure your witness is testifying on what exactly happened on the day, keeping it chronological, keeping it short to the point, and not to be led astray. So from my side, that's pretty much a recap of admissibility and hearsay evidence.
Thank you, Tammy. Thank you for taking us through all that. I don't know if there's any questions from our audience. If you have any comments, please feel free to pop it in the comment section, and then we can deal with it as we go. I see we've got a bit of a tough crowd today. Obviously, you've explained everything pretty well, Tammy, so I really appreciate that. Thank you for being here with us and for recapping us on the last training, as well as taking us through the elements and what it actually means to be a credible witness. I think tying into all that is the next segment of our training, which comes down to the credibility of witness testimony, breaking down the importance. Shakti, welcome, and please take us away.
Thanks once again for having me, Carl, and thank you, Tammy. It was an excellent presentation. Once again, good morning to our viewers, and thank you so much for joining us today. So, look, one comment I would like to have on what Tammy has said is that preparation is key. Proper preparation prevents poor performance. That's what we're always preaching to our witnesses and preaching to our members, should they appear at any forum, at the Bargaining Council or the CCMA or whatever the case is. So if there's a lack of preparation, then unfortunately your case is not going to be very buoyant when it comes to the commissioner deciding on the facts and whatever the case may be. So my topic today is credibility of witness testimony. As Tammy quite correctly pointed out as well, essentially, at the end of the day, a presiding officer, be it a judge, a commissioner, arbitrator, whatever the case is, will essentially have to determine whether or not your story is believable, number one, and secondly, whether you as an individual are a reliable witness. Now, the process that the South African courts and our statutory bodies like the CCMA use is an adversarial one. So at the end of the day, a judge or a presiding officer really functions as a human lie detector. So he or she has to sit there and to ascertain, whether a person is telling the truth when they take the witness stand or whether they're lying. It's quite a difficult thing to do. So therefore, we have all these combined principles about demeanor, your clarity, your consistency, how fast you're talking, whether or not you're making eye contact, that eventually determine how credible you will be as a witness. But I'll touch on that as we go along. Let us start by breaking down the importance of the credibility of a witness's evidence. Firstly, when we talk about credibility of witness testimony, there's ethical considerations. Now, Tammy touched on this as well, but one thing that really can make or break the credibility of a witness is whether or not that person comes across as being ethically minded and demonstrates some form of ethics or the other. So it's important during your testimony as a witness to uphold these ethical standards. If you are insulted, do you insult back? Do you let the process descend into a mudslinging match? No, these are not the signs of a strong witness. A witness needs to maintain their composure, be confident at all times, and brush off insults. As difficult as it might be, but this is something that we need to emphasize in order to convey some form of credibility in a witness. So you often see from the case law as well, cases that have gone to the courts and have been decided, where the presiding officers comment on the credibility of a witness based on their ethics. So it's almost a known fact within South African law is that if you as a witness, whether you're representing the company or whether you're an applicant stating your case, if you have or know of a fact that might support the other side, you should surrender that fact, and should be forthright and forthcoming about all the facts of the case. You'll be surprised that in the final analysis, an arbitrator, a commissioner, a judge will actually find you a more credible witness for making these concessions. So ethics are quite critical to when it comes to the credibility of a witness. Secondly, according to our slide, is avoiding perjury and false statements. Now, it goes without saying, sometimes we might feel that we're under pressure to make sure that we win the case, and from there we get carried away and start telling tales. The legal repercussions of that are quite serious. Perjury is a criminal offense. It's punishable by a fine or a criminal sentence, so actually imprisonment, depending on the seriousness of it. So when it comes to not telling the truth, our members and their witnesses are advised against, contorting the truth or adding a different shade to it or whatever the case is. Also, it will ruin your credibility as a witness. So that's something that we ought to be mindful of when we are talking about credibility of witnesses. Also, thirdly, is the consequences of providing false testimony. If testimony is provided and it turns out or it is found that such testimony is false, then automatically, the case is half lost due to the fact that now the arbitrator, the judge, the commissioner, can't really believe what you're saying. So if you cannot believe a person that is sitting in front of you and giving evidence, will you really find in that person's favor? It's almost common sense, but we see it in practice that people will try and bend the truth and to make their testimony suit their own facts, which must be avoided. Then moving on, there's various factors that affects a witness's credibility. So obviously, you have prepared to go to the CCMA or Bargaining Council on a particular day. You would have spoken to your CEO official representative, who will guide you through all of these aspects. But something that you need to be wary of when you're on the stand is your demeanor. So it's important to sit upright. It's important to make eye contact. We are aware that there's certain cultural practices that prevent people from looking directly in the eye of the arbitrator or the opposing party or whatever the case is. But as far as possible, try and maintain eye contact. It's also important to speak loudly and clearly. This is something that a lot of people don't do, and it actually is perceived that they're scared and they're not telling the truth. So it's important to speak loudly, clearly, and slowly as well. Because as Tammy quite correctly pointed out, and Carl as well, is that these processes are being recorded digitally and as well as manually. So to appear to be credible, you have to be able to demonstrate these capabilities in order for a commissioner or a presiding officer to hear what you're saying. Consistency also boils down to truth telling. You must be consistent in your version. You can't say one thing during your evidence in chief, that's when you start to give evidence, and say a different thing when you're being cross-examined. It's important to be consistent. Here as well, I agree with Tammy, is that don't rush. You're not in a race. You have all the time in the world. These cases have important legal ramifications. So as far as possible, take your time, think about the question, and then when you are ready, you're most welcome to answer it. It's important to be consistent. If you are found to be inconsistent, or if the opposing party, the trade union, the attorney, or whatever the case is, picks up on any inconsistency, that's a loophole to start cross-examining you and trying to undermine your credibility. So it's important to be consistent. With regards to bias, bias or interest, or recognizing and addressing potential bias, as a witness, it's important to be impartial. It's important to be neutral, and just to come across in a way that you're not favoring, because you're a witness for the employer. You're not automatically going to sing their praises. It's important to be neutral and to not to take things on face value. I mean, there's one practical experience that I can share with you is that where a human resources representative of a company here in Durban started to testifying, and only during cross-examination it was uncovered that this person was in a relationship with the applicant in the case. So as you can see, credibility right through the door. Therefore, it's important if there's any bias, if there's any conflict of interest, or whatever the case is, to disclose it and be forthright, ideally before the arbitration, so that steps can be taken to avoid having a situation where it's uncovered during cross-examination that you're a biased witness. When arbitrators and commissioners are also evaluating cases, they look at corroboration. So your evidence has to tie in with the evidence of all the other witnesses. So again, it's not that you should collude with people prior to the arbitration or to tailor a version. It's a matter of during preparation, you need to say to the person representing you, the CEO official or whatever the case is, whoever's representing you, you need to say to them that, look, this is what I know of what happened on that day. Does it necessarily gel with the story of everyone else? You know, as time goes on, time progresses, memories can fade. What could appear to be a red shirt today, 6 months or a year down the line will be a blue shirt. So we need to make sure that during preparation, that the version that you are going to give at the arbitration is consistent and corroborates the version of other witnesses. With regards to expertise, so again, if you are going to be giving evidence of an expert nature, if you're going to be giving evidence of a specialist nature, it's important to articulate this clearly and to qualify yourself before the commissioner or the arbitrator to say that I have an expertise in so and so field, and that's what equips me to testify today. So expertise is not necessarily black and white in terms of a certificate, degree, diploma, or master's degree. Sometimes expertise is your practical experience in the industry. I mean, you can read a book about panel beating, but if you've been a panel beater for 35 years, it's a different story entirely.
100%, Shakti. Sorry, I just want to jump in there to say
Sure.
I think it's extremely important when a representative is introducing a witness as introductory questions to let the commissioner or the presiding officer actually know, how long have you been in this position? How many years of experience do you have? Because it also creates that background for the presiding officer in making a determination on credibility that this person knows what he's talking about. Because although he might not have, a degree to support that he's an expert or qualified, whatever, medical doctor, for example, he is presenting his evidence in an expert manner in the sense that, yes, he's got the experience to back what he's saying. So I think that is also extremely important. And to I want to say, contest that evidence from an applicant's point of view or from an employee's point of view, they would then also have to bring their own expert witness, if I can put it like that.
Quite correct, Carl. You're quite correct. So we often take for granted that, sometimes if people are not qualified in terms of some vocational qualification in a certain field, that we should, frown upon the evidence. But actually, the quite opposite is true. If a person might be qualified in practical experience through life, and that's why they are where they are in the company at the moment. So yes, it's important to be mindful of this, and also during discussion with your representative, your CEO representative, it's important to explain to them that, look, I'm an expert in this field. I've been doing this all my life, 40 years plus. So nobody can lie to me about, panel beating a car or, if you're an electrician or whatever the case is. So that's just another factor that we should add on. Then the next bullet point is general considerations of presiding officers regarding witness testimony where there's a factual dispute. The determination is whether the party burdened with the onus of proof has succeeded in discharging it. In simple terms, as Tammy alluded to, certain cases call for a dispute of fact. So a commissioner is faced with a situation where he has two what we call diametrically opposed versions. So, you have, let's take, for example, an assault case where witnesses and the complainant of the assault say that hypothetically, for example, they were punched in the face, whereas the applicant and his witnesses or her witnesses will say that no, the applicant wasn't actually punched at all. So now the commissioner has a difficult task of dealing with competing witnesses and competing versions of evidence to arrive at the truth. And below are some of the factors that affects a person's credibility. So a presiding officer will look at the veracity of the witness, will also look at their candor and demeanor. So in other words, when we refer to candor, we mean how forthright are they? How confident are they in their case? What's their proclivity to tell the truth? So believe it or not, as I indicated at the outset, magistrates, judges, commissioners are ideally skilled in the act of being a human lie detector. Besides our verbal comments, our body says something completely different. Our body language, our verbal cues, and whatever the case is. So it's important to be mindful of that. There's no harm in, prior to a case, sitting down with your CEO representative and saying, "Look, let's do a test run of this case. I want to testify as a witness. Am I doing fine?" So even though you are telling the truth, sometimes our body language might say something completely different. And this is something, unfortunately, commissioners, arbitrators, presiding officers in general tend to pick up on. So it's something that we should work on. They also look at latent bias and blatant bias. So latent bias is a situation where a presiding officer will actually make a determination that your evidence is skewed unduly towards one side for any number of reasons. And then obviously blatant bias is when you quite categorically say that the commissioner says or finds that you have blatantly favored a particular version. So try to be neutral, try to be objective, try to be honest and open. It will also accentuate your integrity as a witness giving evidence. A commissioner or presiding officer will also look at internal and external contradictions in evidence. So internal contradictions is where you contradict yourself. You say something during evidence in chief, but you say something completely different during cross-examination. That's a contradiction. Or external contradictions as well, where there's 4 witnesses, 3 witnesses say one thing, and unfortunately you say the complete opposite. So that affects credibility and obviously affects the weight of your evidence as a witness. Commissioners will also look at the probability and improbability of the various versions that come before them. And lastly, the caliber and performance compared to other witnesses. I mean, the case as a whole, when the commissioner makes a decision, or the presiding officer will have a look at all these factors and then make a decision from it. So we want to be 100% certain that when we are testifying, we're doing so in good faith, we're doing so confidently, clearly, and honestly, with integrity. So these are things that it comes with practice and also with preparation, which we can't underplay.
Sorry, Shakti, I just want to jump in there quickly. So
Sure.
Under these general considerations, just for the audience to follow, you'll see A is marked credibility of various witnesses. So all the factors that Shakti's now discussed goes under the credibility, which is the general consideration that the presiding commissioner or the presiding officer will determine. But to follow on with that, Shakti will take us through, it's not just credibility, it's also witness reliability and the probabilities. So yeah, that's just to follow on if the audience is looking at B and C now on this page. So it follows on from there.
Thank you so much, Carl, for clarifying. So a commissioner will also consider, or a presiding officer will consider, witness reliability. So how reliable are you as a witness? I mean, it all boils down to how accurately you would have observed the scenario I'm playing. For example, the classic examples is that where you are a witness, let's just say you're a security officer at a company and you observe fellow employees committing misconduct on the site, and the commissioner will now try to ascertain whether your version of events is reliable. Did you actually see? Did you actually see? Exactly what transpired? Were you in a position to see what transpired? How close were you to the incident that was going on, were the lights on, and factors of that nature. So we also refer to quality, integrity, and independence of the recall thereof. So in other words, a presiding officer will have to sit down and really have to ascertain as to whether or not you are saying something that's rehearsed, or it's something that you genuinely believe and say what exactly happened on the date and time. So that's another factor that a presiding officer will consider when evaluating evidence. And then lastly, the probabilities. So if there's two competing versions, a commissioner now has to sit down and weigh, which version is more probable. That's where a commissioner or presiding officer has sort of a checklist of both sides of the case, the applicant side and the employer side. And then we'll have to weigh up the probabilities. So, and then ultimately decide which version is more probable. So the credibility of witnesses play an important role, the consistency of their evidence, the accuracy of their evidence, that there's no material contradictions, that the witnesses corroborated each other, and whatever the case is. So in order to put together or put forth a polished case before a commissioner or presiding officer, preparation is key. To sit down as a group with the witnesses and to really go over everything once more, maybe 2 or 3 times more, just to make sure that we're all on the same page. In my practical experience, a lot of cases were actually unsuccessful because preparation was lacking. Witnesses took what was required of them for granted. They thought that they could recall an event, but actually time has passed and things have changed. So it's important during preparation to make sure that we put forth a robust version before the commissioner. Because when the probabilities are decided by a presiding officer or commissioner, this might count against you.
So, sorry, Shakti, just to jump in there, I was going to say, now I think you'll be dealing with this under the tips for our members and prospective members, but the naturalness of testimony,
Yes.
that it doesn't sound like, as you said, too rehearsed. And something that I always ask or wonder when I listen to witness testimony, say there's a long time that has elapsed between the incident occurring and the arbitration that takes place, or maybe even in the labor court, how well that witness recalls the events. Also, I raise an eyebrow to think, it sounds like this just happened yesterday. And one of the questions I ask myself is, how much did you rehearse this? Because it doesn't sound natural, having recalled it so accurately, if I can put it that way. So I think natural testimony also plays a big role for the party listening or the presiding commissioner listening to it.
Correct. I mean, it all boils down to believability. I mean, if you're going to recall facts and figures from 10 years ago as accurately as if it were written yesterday, it might, as you say, raise an eyebrow. But on the same token, the evidence that comes across must come across organically, and that it's not like it was contrived or rehearsed or whatever the case is. So it's something difficult. I mean, if you have documents prepared, a bundle of documents, there's no harm in telling the presiding officer, may I please refer to the bundle of documents, or say to the representative, could you please direct this to me in the bundle of documents so that we can be clear?
100%. I think the representatives from CEO as well, our dispute resolution officials, will also use the bundle to guide the witnesses, that they don't have to recall everything out of the top of their head. Turn to page whatever. Can you read the top of that page? Can you elaborate more? So the representative, or an effective representative, will also guide the witness through their testimony. It's not just the witness dropped off in the middle of nowhere and they have to find their own way through the arbitration proceedings. But thank you, Shakti. Yeah, thank you, Shakti. If we can move on to the tips. Sorry, I see we are running a bit short of time, but you don't have to rush through it or anything. We just want to
No problem.
the tips there. Thanks,
No
Shakti.
problem. So some of the tips of being on being an effective witness are as follows. It's not an exhaustive list. A lot is common sense, and obviously will depend on your preparation with the CEO official. So first and foremost, tell the truth. No rocket science there. It's something that we have to pay particular attention to. Lying during testimony is absolutely forbidden. Secondly, again, what Tammy and I have been preaching is that we need to be prepared. As I always say, proper preparation prevents poor performance, or P to the power of 5. And that's essentially what it means. If there's no preparation, your case will unfortunately be lacking. Again, as Carl alluded to earlier, another tip is to listen carefully. Active listening paying close attention, no matter how upset somebody makes you during the process, whether the applicant looks at you funny or the representative of the applicant belittles you, it's important to remain confident and listen carefully to the questions, because there's numerous ways that people asking questions will attempt to destabilize you and destabilize your evidence. So it's important to maintain your composure at all times. Furthermore, answering directly. So be as succinct as possible, as concise as possible. Answer the question directly. Do not deviate. What Tammy touched on with relevance as well. A witness who waffles is not somebody that the presiding officer likes. I mean, they'll have to now sit and wade through your evidence, which is voluminous and doesn't really tie with what's being dealt with at the arbitration.
Waffles are only for breakfast, Shakti.
Definitely. Another important factor is avoiding guesswork. Nobody likes a speculator. So deal with facts and figures, the true things of what happened. Do not volunteer an opinion as what could have happened or what should have happened. That's not your terrain as a witness. Stick to the facts and discuss only the facts. Again, a point that I touched on earlier is stay calm and composed, no matter how difficult the questions may become, or how uncomfortable you feel during the process, because it's not something that everybody goes through on a daily basis. Try to stay calm and composed. Ask your representative, or even ask the presiding officer, if you feel that that you're not doing too good, that you would like to have an adjournment for 5 minutes so that you can compose yourself. Respect the forum, whether it's at the CCMA, the Labour Court, or even the Constitutional Court. You treat all presiding officers with the same level of respect. You treat all language practitioners with the same level of respect, and you treat all representatives with the same level of respect. It is a formal situation, and the outcomes of these forums can have significant legal consequences. So please be mindful of the forum that you're in and respect it. Avoid being argumentative. I mean, that's one way to deflect the direction of any arbitration, is to enter into an argument and things come out that shouldn't have come out. So stick to the facts. Avoid being argumentative. Point out to your representative or to the commissioner that this is becoming an argument. You're there to give evidence and you're not there to argue with anyone. Again, the next tip is be mindful of non-verbal communication. So again, body language, facial expressions, tone of voice, all convey a certain message. Also, rolling of the eyes, absolutely forbidden. I see that happens quite a lot, but stay away from that. I mean, commissioners don't like that. They think that you're belittling the process. Stay focused. It's easy to lose direction, especially when you're under pressure, when you're nervous, but stick to the facts and you will be victorious. Importantly, don't memorize your testimony. What Carl said again is that you don't want it to be appear that you're an actor in a soap opera. It must be as natural, instinctive, and reflexive as possible. So stay away from memorizing things. Also, I've observed during practice is that when a party or witness memorizes something, and when things are not going according to script, and if you ask a question that you're not expecting, it can destabilize you as a witness. So try to recall things as they occurred and as you have them stored in your mind. So do not memorize your testimony. Most importantly, be patient. The whole process of our legal system in South Africa is designed to actually take a lot of time. When a witness says something, to when it's interpreted, to when the presiding officer asks for clarification, and then it ultimately is stated, it takes a lot of time. You might find it to be pointless. You might find it to be a waste of your time. But it's important while you are there and you're part of the process, you have a job to do. It's important to be patient and not lose your temper. Be concise. Again, stick to the facts. Be as quick as possible and as accurate as possible. Furthermore, following the rules, you can discuss this with your CEO representative, and just be aware of what is permissible, what you can do during the arbitration, what you can say, how you should come tied to the process, and so forth. These are important characteristics that can affect your credibility at the end of the day. Seek clarification if needed. Don't ever assume that, don't ever assume a question, and don't assume the answer. Be certain about it. If you are uncertain, say it to the commissioner, say it to your representative, I need some clarity on this question. You'd rather be clear than to cause more confusion in the case and ultimately, unfortunately, be unsuccessful in the matter.
Sorry, Shakti, I just want to jump in on that point. I think it's important, and maybe not all witnesses or people who become witnesses know this, is that once you are under oath and you are testifying, your representative can't assist you through maybe when you're being cross-examined. If you've been asked a question by the other side, I can't, or as a representative, can't jump in and say, can you clarify that question for my witness? You can't disrupt the proceedings or the flow of it. So the witness, to a certain degree, is on their own in cross-examination. Yes, you, as a representative, you can make certain objections, but if you don't understand the questions of the witness, it's important that, again, be patient and you can ask, listen, I don't understand that. Can you please rephrase it? Or can I get some clarity? And it's important for witnesses to know that they have this option to respond in that way without it tanking their credibility.
Thank you for pointing that out again, Carl. And then lastly, the last step is to maintain professionalism. Look, we all have our own realities going on, our own situations, our backgrounds, and so forth. But when you are there representing your company and flying the flag high, it's important to dress appropriately, to maintain the correct posture, and to basically come across as a person who respects the forum and is there to tell the truth. Be welcomed at all times. And this has an effect also on your credibility. These are simple things, but it often gets neglected, even with larger corporates and so on. You sometimes find, or you often ask yourself, is that whether that person really belongs in that corporate organization. So be professional, dress appropriately, and conduct yourself in a professional manner at all times. Avoid colloquialism, avoid vulgar language. And yeah, just try to adhere to the rules of the process.
If I can just jump in there,
Yes.
just as a
Yes,
last
of course,
point, what Shakti was saying, I think a lot of the times people in certain positions, like in corporate positions, there's also, I think, unfortunately, a misconception that some witnesses will know what to do. They will know how to dress. They'll know how to respond. And I think that could be a bit of a stumbling block where people have that automatic expectation of, no, our witnesses will know what to do. And I think that, again, goes back to the preparation. Rather be over-prepared and let your witnesses know exactly, go through things, because there might just be one of those examples that Shakti went through that they thought, oh, actually, I did not know that. And you don't want something as silly as your dress code or your demeanor or getting frustrated to challenge your credibility. So I think to never assume that any witness is prepared based on the length of service. I think in any case, there should be preparation, no matter how experienced.
Absolutely.
I 100% agree, yes. No, thank you, Tammy. Thank you for that input there. I see we have comments over here. Great presentation, Tammy and Shakti. Thank you so much for the comments there, guys. Is there anything else that you'd like to add, Shakti or Tammy?
No, thank you so much.
100%. To our audience, if you have any questions or comments, please feel free. We will check them on social media afterwards. There you can just check the banner over there to follow us on LinkedIn and Facebook. If you wish to view this, or maybe you've missed a segment of it, it will be made available, as I said at the beginning of the presentation. The slides and the recording will be available and reposted for you guys to watch after the fact and access at any time you guys feel comfortable with. When it comes to further training and development, obviously from us at the CEO Training Department, we're constantly looking for further training opportunities and ongoing development to confine this content to, get it across to our members and prospective members in a way that is informative. So if there are any comments or suggestions, please feel free to critique as well. We can only learn and grow from that. So I'd really appreciate your guys' feedback from the audience. Thank you so much for your time, Shakti, Tammy. Thank you guys so much for being here.
Thank you.
When it comes to specific member and prospective member training as well, you guys can also pop us an email if you're looking for something specific. We do offer external training to our members when it comes to specific training when it comes to CCMA and Bargaining Councils. So our training schedule for the rest of the year, we are looking at training once a month. We will be advertising our following session in due course, so please stay tuned for that. And yeah, from my side, thank you for this informative session, Shakti and Tammy. Our details are on the screen for the audience if anyone wishes to give a comment or contact us directly. And then we are also available on our website, on Facebook, LinkedIn, Instagram, and Twitter if anyone wishes to like and follow there. Thank you, everyone, for your time. And yeah, hope you have a great day further.
Bye-bye.